If there is no objection, the journal of proceedings of the trial are approved to date. Without objection, so ordered. The Sergeant-at-Arms will make the proclamation.
Hear, hear, hear. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The Majority Leader is recognized.
Today, the Senate will conduct up to 8 hours of questions to the parties delivered in writing to the Chief Justice. As a reminder, the two sides will alternate and answers should be kept to 5 minutes or less. The majority side will lead off with a question from the senator from Maine.
Mr. Chief Justice,
The senator is recognized.
I send a question to the desk. On behalf of myself, Senator Murkowski, and Senator Romney.
This is a question for the counsel for the president. If President Trump had more than one motive for his alleged conduct, such as the pursuit of personal political advantage, rooting out corruption, and the promotion of national interests, how should the Senate consider more than one motive in its assessment of Article 1?
Mr. Chief Justice, Senators, in response to that question, there are really two layers to my answer, because I'd like to point out first that even if there was only one motive, the theory of abuse of power that the House managers have presented, that subjective motive alone can become the basis for an impeachable offense, we believe is constitutionally defective. It is not a permissible way to frame a claim of an impeachable offense under the Constitution. But I'll put that to one side and address the question of mixed motive. If there were a motive that was of public interest but also some personal interest, we think it follows even more clearly that that cannot possibly be the basis for an impeachable offense. And even the House managers, as they have framed their case, they have explained, and this is pointed out in our trial memorandum, that in the House Judiciary Committee report, they specify that the standard they have to meet is to show that this is a sham investigation. It's a bogus investigation. These investigations there's not any legitimate public purpose. That's the language, any legitimate public purpose. That's the standard they've set for themselves in being able to make this claim under their theory of what an abuse of power offense can be. So it's a very demanding standard that they've set for themselves to meet. And they've even said they came up and they talked a lot about the Bidens. They talked a lot about these issues in 2016 election interference, because they were saying there's not even a scintilla of any evidence of anything worth looking into there. And that's the standard that they would have to meet, showing that there's no possible public interest and the president couldn't have had any smidgen even of a public interest motive, because they recognize that once you get into a mixed motive situation, if there's both some personal motive but also a legitimate public interest motive, it can't possibly be an offense. Because it would be absurd to have the Senate trying to consider, well, was it 48% legitimate interest and 52% personal interest, or was it the other way? Was it 53% and 46%? You can't divide it that way. And that's why they recognize that to have even a remotely coherent theory, the standard they have to set for themselves is establishing there is no possible public interest at all for these investigations. And if there is any possibility, if there is something that shows a possible public interest, and the president could have that possible public interest motive, that destroys their case. So once you're into mixed motive land, it's clear that their case fails. There can't possibly be an impeachable offense at all. And think about it, all elected officials, to some extent, have in mind how their conduct, how their decisions, their policy decisions will affect the next election. There's always some personal interest in the electoral outcome of policy decisions. And there's nothing wrong with that. That's part of representative democracy. And to go start saying now that, well, if you've got a part motive that's for your personal electoral gain, that that's somehow going to become an offense, it doesn't make any sense. And it's totally unworkable. And it can't be a basis for removing a president from office. So the bottom line is, once you're into any mixed motive situation, once it is established that there is a legitimate public interest that could justify looking into something, just asking a question about something, the manager's case fails, and it fails under their own terms. They recognize that they have to show no possible public interest. There isn't any legitimate public interest. And they've totally failed to make that case. I think we've shown very clearly that both of the things that were mentioned, 2016 election interference and the Biden-Burisma situation, are things that raise at least some public interest. There's something worth looking at there. It's never been investigated in the Biden situation. Lots of their own witnesses from the State Department said that on its face, it appears to be a conflict of interest. It's at least worth raising a question about, asking a question about it. And there is that public interest, and that means their case absolutely fails. Thank you.
Thank you, counsel. The Democratic leader is recognized. The Democratic leader asks the House managers. John R. Bolton's forthcoming book states that the president wanted to continue withholding $391 million in military aid to Ukraine until Ukraine announced investigations into his top political rival and the debunked conspiracy theory about the 2016 election. Is there any way for the Senate to render a fully informed verdict in this case without hearing the testimony of Bolton, Mulvaney, and the other key eyewitnesses, or without seeing the relevant documentary evidence?
Thank you, Mr. Chief Justice. The short answer to that question is no. There's no way to have a fair trial without witnesses. And when you have a witness who is as plainly relevant as John Bolton, who goes to the heart of the most serious and egregious of the president's misconduct, who has volunteered to come and testify to turn him away, to look the other way, I think is deeply at odds with being an impartial juror. I would also add in response to the last question that if any part of the president's motivation was a corrupt motive, if it was a causal factor in the action to freeze the aid or withhold the meeting, that is enough to convict. It would be enough to convict under criminal law. But here there's no question about the president's motivation. And if you have any question about the president's motivation, it makes it all the more essential to call the man who spoke directly with the president, that the president confided in and said he was holding up this aid because he wanted Ukraine to conduct these political investigations that would help him in the next election. If you have any question about whether it was a factor, the factor, a quarter of the factor, all of the factor, there is a witness, a subpoena away, who can answer that question. But the overwhelming body of the evidence makes it very clear. On July 26th, the day after that phone call, Donald Trump speaks to Gordon Sondland. That's that conversation at Ukraine restaurant. And what does Gordon Sondland, what is the president's question of Gordon Sondland the day after that call? Is he going to do the investigations? Now, Council President would have you believe the president was concerned about burden sharing. Well, he may have had a generic concern about burden sharing in other contexts. But here, the motivation was abundantly clear. On that phone with Gordon Sondland, the only question he wanted an answer to was, is he going to do the investigation? Now, bear in mind, he's talking to the ambassador to the European Union. What better person to talk to if his real concern was about burden sharing than the guy responsible for Europe's burden sharing? But did the president raise this at all? Of course not. Of course not. And if you have any question about it at all, you need to hear from his former national security advisor. Don't wait for the book. Don't wait till March 17th when it is in black and white to find out the answer to your question. Was it all the motive, some of the motive, or none of the motive? Now, we think, as I mentioned, the case is overwhelmingly clear without John Bolton, but if you have any question about it, you can erase all doubt. Now, let me show you a video, underscore number 2, slide 2, how important this is.
As House managers, really, their goal should be to give you all of the facts, because they're asking you to do something very, very consequential. And ask yourself, given the facts you heard today that they didn't tell you, who doesn't want to talk about the facts? Who doesn't want to talk about the facts? Impeachment shouldn't be a shell game. They should give you the facts.
Last video, which is even more important and on point for Mr. Bolton. Number 3.
And once again, not a single witness in the House record that they compiled and developed under their procedures that we've discussed and will continue to discuss provided any firsthand evidence that the president ever linked the presidential meeting to any investigations. Anyone who spoke with the president said that the president made clear that there was no linkage between security assistance and investigations.
No, that's not correct, right? Because, of course, Mick Mulvaney said that the money was linked to these investigations. He said, in acknowledging a quid pro quo, they do it all the time and we should just get over it. Gordon Sondland also said, the president said, on the one hand, no quid pro quo, but also made it clear that Zelensky had to go to the mic and announce these investigations.
Thank you.
Thank you, Justice.
Mr. Chief Justice.
All right,